right? So what do we mean by closely held corporation? A closely held corporation is a corporation that's owned by only a few shareholders. The shareholders are often involved in management, and they may have buy and sell agreements. In other words, to keep it as a closely held corporation. Now, why would someone do that? Remember, in a publicly held corporation, you have formalities that are required, right? You have to file an annual statement. You must file quarterly statements. And I don't want to get too far into it yet, because we get to it a little bit further. But an annual statement is called a 10K. Must be filed with the SEC. Must be. A 10Q is a quarterly statement. Must be filed with the SEC. If a material event happens, like the CEO dies in a plane crash, you must file an 8K with the SEC to notify the public. Those are called corporate formalities. If you don't do it, you can lose your corporation status and be dissolved. Okay? So, if you're a small enough corporation, you don't have to follow all of those formalities by electing, by way of the shareholders' majority vote, to be a closely held corporation. And if you are a closely held corporation, meaning no more than 50 shareholders, then you can dispense with some of the formalities. You don't have to have a board of directors. The shareholders can manage without losing liability. And so, a closely held corporation, as long as you meet the parameters, can be in existence and run the way the shareholders want it to run with direct involvement in management. Everyone got that?
Yes. I have a question. Does it relate to the public corporation or private corporation?
Does what relate?
The closely held corporation.
A closely held corporation is a corporation that's only held by a few people.
So it's separate from what we talked before?
Yes.
Okay.
Yes. And if you have 50 or fewer, and you have usually buy-sell agreements to make sure it stays 50 or fewer, or make sure it stays the type of people you want, like, say it's a family member. It's a family. Closely held corporation is a family. And we want to make sure that only the family members own this corporation, because we're participating in management and everything. We can have a buy-sell agreement that says if a family member wants to dispense with their shares, they have to first offer them to another family member. Okay? And that's how we control and keep it closely held. Because if it gets over 50 people owning it, it can no longer be a closely held corporation. So now we got to do the corporate formalities, right? Yes?
So it's not a publicly traded company?
No.
So when the shareholders move their shares are over? No.
Right. They're sold between each other, usually.
They're
sold amongst each other with a buy-sell agreement. We're determining what?
Is there a price for the shares?
Yeah, whatever price I said, if someone's willing to buy it, say I want to sell my shares for $50 a share. If I have a family member that I have to offer them to first, if they're willing to buy, they can. If they won't buy them, then I can go out and find somebody else, but I can't put it on the public market because it's not publicly traded. Publicly traded, by definition, is filing what's called an S1 registration statement with the SEC. That's going public. If you get into insecurity. All right? So we got this.
I have a question.
And the reason, okay, just a second. And the reason for this is so that I can do management the way I want to as a shareholder, as opposed to being forced to use a board of directors and all of that stuff. All right? That's one type.
You said no board of directors?
You can decide not to have one.
Oh.
Okay? Yes, Tamiko.
Okay, so this is a closely held corporation would be the type of corporation that an individual would want or a family would want.
Right. Where you want to be able to control it directly, as opposed to having a board of directors. I want to be a shareholder and run the thing and not have to answer to anybody else. Okay? And I want to have effective management. I don't want to have to worry about if I don't file an annual statement, I'm going to lose my status. Because I can get rid of all those formalities as long as I stay low, as far as number, and I don't have to be I'm not so controlled by regulations. It's a way to get out of the regulations of a corporation and still have the limited liability shield. Okay? As opposed to, and there's your book has it, page 681 has a little bit more about what a closed corporation is. And then there's another corporation that's called an S corporation, which we'll get to in a minute. But I want to go back to profit and nonprofit. Okay? So a profit company, corporation, or for-profit corporation is one created to conduct a business for profit. Common sense, right? It distributes, its profits to the shareholders in the form of dividends. Remember I talked before about the two ways for a owner of a corporation to make money? Increase in or appreciation in the share price, right? And dividends. So if you're a profit corporation, you want to get dividends as a shareholder, right? You can do that. You could also be a non-profit corporation. Name a non-profit corporation. PETA, Salvation Army, United Way. A corporation is a non-profit corporation if it is formed to operate a charitable institution, college, university, and other non-profit entities. PETA. And the big difference between a profit corporation and a non-profit corporation is, can a non-profit corporation have profits?
Yes.
Yes? Anyone say no? A non-profit corporation can have profits, however, it cannot distribute those profits in the form of dividends. Cannot. And what's the rationale behind that?
It's not an investment.
It's a charity.
Well, it could be a charity, but it could be a college.
Because then somebody's making a profit, so it can't be non-profit if somebody's making a profit.
Well, they can have a profit. Here's the idea behind it. If I'm the United Way or the Salvation Army, I'm a non-profit corporation, but I could have millions of dollars in earnings retained, right? But the idea is behind it is this. Who are you getting your millions of dollars from? Donations from the public, right? Well, those donations from the public are used because the public wants to give money or donate money to something that will do something, right? Like if I'm an animal lover and I want to make sure animals are treated fairly, and there's a group out there called PETA that does just that, I want to donate to PETA, right? But I don't want somebody to be profiting from that. I want the money used to fulfill the purpose of what I'm donating to.
Right.
Protecting animals. So if PETA gets millions and millions of dollars, it can't distribute it to shareholders. It has to keep that millions and millions of dollars to do what it says it's supposed to do. And by following those rules, it gets to keep its tax-exempt status.
Right.
So when I donate to PETA, PETA doesn't pay taxes like a regular corporation because it's a non-profit. Salvation Army, United Way, they collect millions of dollars, right? So that when a disaster happens, they can help. They can help people, right? So if they are in a position where no disasters happen for several years, and they got millions and millions of dollars, they have to keep that money or invest it in very, 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 very conservative investments so that it either grows or doesn't diminish. So that when a disaster does happen, they can fulfill their nonprofit purpose. If they were to take those earnings in years that were lean and pay them out in dividends, what happens if a disaster happens? They have no money. Well, you had money, but you gave it away. You were supposed to keep that money so that you'd be ready when the disaster happens. That's what a nonprofit is. They can have plenty of profit, just cannot distribute it out in dividends like a profit corporation can. Understand the distinction? Yes?
So they don't have shareholders. They have a board, but not.
They do, but the shareholders are people who, all right, when you set up as a nonprofit, you're set up the same way. You've got a board of directors, okay? Board of directors, you've got the president, CEO, and all those people. Those people can be voted in and out by people who donate, okay, when there's a meeting or different types of things that might happen, but they're accountable to the public as people who donate, all right? Not in the extent of a shareholder that's going to a profit corporation. So you're still going to look at how they do what they do and make a decision as to whether or not they stay in office. But it's different from the way that a profit corporation runs.
Well, I mean, like, the University of California is run by a board of regents, which is appointed by, I believe, the governor. So the shareholders don't exist. They're just a governor.
The shareholders in the region, right? The way that we as shareholders for the University of California work, as far as that is we vote for the governor, right? The governor appoints the regent. The governor can dismiss the regent or what have you, but if we're unhappy about that, we go and complain to the governor. What's he going to do with the regent? Put pressure on him in order to get him to do what we as the public want. So in that respect, we control that because it's a non-profit institution, all right? But it's run by appointment, but we as the public get to vote in and out the person who does the appointment.
So depending on the nonprofit, the shareholders can be subsumed to or almost non-existent or
almost
layers of technical.
Almost, yeah. It can be hard to get to how to get rid of a person like that.
Right.
But the idea is that there's no shares being paid out, and the idea is they keep money that they have and they get a tax-exempt status, all right? And how you can get rid of a person here is, let's say, the owner of Salvation Army starts, it's found out that they embezzled money. Who's going to come down on them? Who's going to come down on them is the people who donate that find out about that. They're going to complain to the IRS, right? IRS is going to do an investigation. Find out that those people embezzled money and they were on the board of the Salvation Army. So IRS is going to say, Salvation Army, either you get rid of these people or we're going to revoke your tax-exempt status, which could put the Salvation Army out of business. So that's how we as the public may get rid of someone like that, right? Yeah.
So like with PETA, do the people that donate vote on the board of directors? Like the people that donate like millions or whatever every year, the ones who donate the most, are they the ones that vote on who will be the board of directors, or how does that work?
They can, depending on how it's set up, how PETA is set up. But it's still a corporation that has a charter, right? Right? So you have to look at the bylaws and see what it says with respect to removal of people from the company, how they do their meetings or what have you. And if you are an individual that fits within whatever the parameters are, you donate $10 million or whatever, or you donate $10,000, you have a right to vote. So if I'm just a regular person donating and I don't meet the parameters or whatever the bylaws are, I may not get a vote. If I'm a major donor and it says in the bylaws, all people who donate at least $10,000 in a year have a right to vote. When that annual meeting comes around, I put in 10 million or 10,000 or whatever the threshold is, I get to go to the meeting and vote. But then in this case, Robert, if I just donate $100 for tax purposes in a year, and the bylaws say that doesn't give me an entitlement to vote, then I can't vote.
So it's just a case-by-case basis.
It depends on what the bylaws say. Yeah. But again, you know, companies are set up such that they have certain ideas in mind as to who they want to be involved in the ability to vote. So they're going to make it a threshold, and they're going to promote themselves to those individuals, so that so that Peter keeps on being able to be what it wants to be. Yeah.
For the ACLU, that's a non-profit corporation, right?
Mm-hmm.
Now, some non-profit organizations are tax deductible, right?
Well, all nonprofits, all right, ostensibly are what's called 501c. 501c3. Thank you. And what that means is that is the section in the IRS code that allows them to be to not have to pay taxes. So that's the key behind being nonprofit. You don't want to pay taxes, right? Because if you're already a charitable organization, you got to get money by donations, right? You don't want to have to get donations and then pay taxes on it, because that reduces your effectiveness. So because you're being a charitable organization to help do things that the government would otherwise have to do, they give you a tax break. Okay? You don't have to pay taxes. Churches are like that. All right? But in exchange for that, you have to run it a certain way to maintain your tax exempt status. All right? Let's not get too far into it, but yeah. Who says that they do? Yeah, the board is going to set the wages. Yeah. For the most part, yes. Yeah. But that kind of gets shady because you get things like Kaiser and things like that. So, yeah, it can be. All right. Without getting too far into that, let's go. Joe.
Yeah, I was curious. There's probably something different I want to because I donated monthly to the ACLU, but they sent a statement saying it's not tax deductible. So I was like, well, why isn't it tax deductible? Because I think it's not profit. But it's probably a different reason.
I don't know what the reason would be, but I think, if I'm not mistaken, ACLU is a non-profit organization.
I would have thought so too, but there's
I don't really give a damn.
Thank you for your contributions.
Are you determining where the contribution goes?
I don't know. 2 days.
Well, all of us when we donate to a charity, the charity doesn't pay taxes, doesn't pay taxes on it, but we get a tax write-off.
Right.
We get to claim it on our taxes. And the reason for that is to encourage us to give, right?
Right.
But what was your question?
Well, I'm just thinking maybe that would be the reason they sent him the statements, because I would get them from my church too. For my monthly ties to my church, they would send me a statement saying, this is what you gave us this month, and I always just used it for my taxes.
But you can write your taxes off with that.
Right.
You're saying you can't.
For the church, I know you can.
Right.
Many of them you can. For ACLU, you cannot.
Maybe it's not tax.
It's not a nonprofit.
Joseph, maybe it's not a nonprofit. Maybe I thought it was, but I have no research. But maybe it's not a nonprofit. It might not be. Okay, so a professional corporation is a corporation formed by lawyers, doctors, and other professionals. The shareholders, like in an LLC, are called members. They're not usually liable for torts committed by members or agents, and the liability is usually imposed for malpractice of members. So if the members of a professional corporation commits a tort or malpractice, then the members can be liable. That's similar to that situation with Antonucci, where the two medical doctors, one performed a malpractice and the other one was liable too. Same situation here.
Wait, I'm confused. Liability is imposed on an individual for malpractice?
Here, right here, liability is usually imposed for malpractice of members. If you're a professional corporation and you're a doctor, and one of you commits malpractice, the other doctors can be found.
The corporation is liable, or
the corporation is going to be liable, yes. Okay? Because if I'm ABC Corporation and I'm a doctor that's a member or owner of that corporation, and I commit medical malpractice, you bet the corporation is liable.
But also the individuals?
The members can be liable as well.
So it could be both.
Yes, yes. Just like the case that I gave with the two doctors who were in their private practice. One committed malpractice, the other one didn't, but they were partners, and both were found liable.
Then why does it say members not usually liable for being committed? Is it malpractice support?
Not usually, it is, but they make an exception for malpractice when it's a professional corporation. Because the idea is you're a professional. You're not just running a business, you're a professional. You went through a specific type of training to become a doctor, right? You ought to be an expert as a doctor. If you commit malpractice, all right, which is a tort, you're going to be found liable. Now, if you hit someone in a car accident on the way to your, hospital or to your practice, that's a tort. You can get out of the liability of that. Okay? But we're going to specifically say because you're a professional corporation, if you commit malpractice, that's your profession. You're not going to be able to get around the tort liability.
So, like lawyers would be better off with the LLC over a corporation.
That's why most lawyers are LLP. That's exactly
What's
why.
the difference between LLP and this?
This issue right here, for one, is that in an LLP, you're not going to have the same requirement of the malpractice and being liable. It's only going to be up to your capital contribution that you put into the company. Whereas here, if you're a professional corporation, you might be found liable for malpractice.
So why that doctors then have this LLP in a case? Why didn't they make this? So they wouldn't be liable for each other's.
No, they would have been liable. Because here's malpractice, right? If
But
one was guilty, the other one is too, they wouldn't get out of the liability by being a professional corporation. This is harder.
What is that? What does it mean, the last one?
Malpractice?
No, the whole sentence.
Liability usually imposed for malpractice of members. If I'm a doctor and I go to take out someone's spleen and I take out the kidney instead, that's malpractice. If I commit that malpractice, my corporation is liable for the tort, and I am too. Okay? Personally. Even though otherwise only the corporation would have been liable. And they say that because malpractice for a professional means you should have a standard that you at least don't commit malpractice. You might hit someone as a drunk driver, which is a tort, okay, on your way to do corporation business. The corporation will be responsible for that, and you'll be responsible for your tort, but the other doctors won't be. But if you commit malpractice, you're going to be liable, corporation's going to be liable, and the other doctors might be liable too. So it makes the doctors look after each other if we're all members and make sure we're all up to snuff, right?
No,
In this professional corporation.
but in LLP also.
We're not talking about an LLP though, because that's why I said I want you to kind of focus in on the one we're talking about, because you'll get confused, and it'll get confusing. But in the LLP, you have limited liability, right? Right?
Yes, but one doctor was responsible for another one too.
Right, but I don't know if
That wasn't
Antonucci was an LLP.
Wasn't.
LLC.
It wasn't an
General
L.
partnership.
General partnership. Okay, so that's why I don't want to get all confused. If the other one was a general partnership, all the partners are equally liable, right? Right? That's the difference. It wasn't an LLP where there's limited liability. If it's a professional corporation, you got malpractice. If it's a general partnership, it doesn't matter because you're liable anyway as a general partner. Always. Right? Make sense?
Yeah, are we gonna compare all those businesses at the end?
I will try if I have time.
Like to
But generally-
distinguish, because it gets confusing. So are we gonna like distinguish one from another?
Well, I try to drop in here and there when I'll say, so price this, that, but it gets confusing when we start trying to mix it in. That's why I say only focus on what we're talking about at this time. Because if we do start trying to mix it in, it will get confusing real quick. Because even within the issue we're talking about here, right? So, are we clear on this so far?
Yes.
Selecting a state for incorporation involves the fact that a corporation can only be incorporated in one state. Even though it can do business in all 50 states, it can only have one state of incorporation. And what is that state of incorporation called? Or what is it called if you're a corporation incorporated in the state of California? In California, you are what type of corporation?
Domestic.
Domestic, right?
Domicile.
Well, you're a domestic corporation. That means that's the state that you are incorporated in. No, not necessarily. I'll get to that in a minute. So the state in which you have, and what do I mean by incorporated? I mean filing your articles of incorporation. Where you file your articles of incorporation are the state that you are incorporated in. And that state is called the domestic state. Okay?
Right.
So if California is the place that we have filed our articles of incorporation, we are a domestic corporation in California. Got it?
Right.
With respect to every other state in the United States, I, as a corporation incorporated in the state of California, with respect to every other state, I am a foreign corporation.
Right.
We have that. All right, so state of incorporation, you're domestic. Every other state, you're foreign. Now, if I am a corporation like Toyota that's incorporated in another country,
Alien.
with respect to any state in the U.S., I am called an alien corporation. Or if I'm incorporated on another planet in the future, I would be an alien corporation. All right? We got that. Now, here's where it gets kind of weird. Maybe not. The state of incorporation, here's where it becomes important, where you incorporate. The state of incorporation determines the laws that pertain to your corporation. What that means is how I run my business, how I deal with lawsuits, what can and can't be done is determined by the state's codes that I am incorporated in. 60% of all the Fortune 500 companies are incorporated in one state,
Delaware.
Delaware. Want to know why? Anyone know why?
You mentioned it because they were
Poison pills, staggered board.
The state of Delaware has a 200-year track history dealing with corporate issues. The state of Delaware has a special court that does nothing but deal with corporation issues. That court is called a chancery court. And in the chancery court, there are no jury trials. There are only judges who decide. And these judges decide nothing but corporation issues. So, whereas in a regular civil or criminal trial, I, as a prosecutor or plaintiff's attorney, what am I trying to do? Get a jury that's going to be sympathetic and emotional to my side so I can win. Whether I'm right or wrong, if I can get an emotional jury that can get on my side, I might win.
Right.
Can't do that in Delaware. The jury trial is not available. Only unemotional judges who are experts in business issues And that's all they do. And Delaware courts are infamous or famous for deciding corporate issues in ways that lean heavily in favor of corporate management.
Mm.
So if there are shareholder disputes against the way a corporation is being run, the Delaware courts lean heavily in favor of the corporate management. So if I'm a corporation, where would I want to incorporate most likely?
Delaware.
A place where my management decisions are not going to be questioned as severely, right?
Right.
When we get into the Disney case, you'll see what happens when that's the case. So, let's say I am Ford Motor Company. Okay? Major big time corporation. Ford Inc. Where do I want to be incorporated?
Delaware.
Delaware. What am I in Delaware? I'm a what? Domestic corporation in Delaware.
Right.
Okay? So that my company's laws are going to be based on what the Delaware legislature says. Right?
Right.
But because I'm Ford Motor Company, I want to be where the motor car industry action is, right?
Right.
Where's that? Detroit, Michigan.
Michigan.
So where's my headquarters going to be?
Right. Ghost town.
Where's my headquarters? My HQ is in
Michigan.
I'm a domestic corporation that's incorporated in Delaware. I have my headquarters office in Detroit, Michigan. What am I in Michigan? A foreign corporation.
That's right.
Right? Want to see that? Where can I do business? Do business all 50 states, right?
Right.
I simply go to those states, file a certificate of authority with the Secretary of State, which basically tells them I'm here. I want to be able to prosecute lawsuits if I need to, so I need to let you know that I'm here. You authorize it? Yes. Now they can sell cars everywhere. Make sense?
Yes.
So they're a foreign corporation in the state in which they're incorporated in this case, and with respect to all the other states, but they're a domestic corporation in Delaware.
So to be incorporated in Delaware, they don't have any office space or nothing?
Nope. Don't have to. Don't have to have a spot at all. They do have to have an agent for service of process if they do business there. We'll get into that too. Yeah, Joseph.
The certificate of authority is required for any state that they're doing business, except for the state that they're incorporated, right?
Right, because they filed us articles of incorporation. Yeah. And if they don't file a certificate of authority in a particular state, then they can't defend themselves in the law. They can defend, but they can't prosecute a lawsuit. So that's the caveat, right? I think we talked about that in another business forum, right? That's why you want to do that. Because if you get sued, you can always defend yourself, right? Because a corporation is a person, so it has a right, just like you and I, to have a presumption of innocence, right? So it can always defend itself. But if there's a breach of contract in a state that it's done business and it hasn't filed a certificate of authority, it can't prosecute the suit. Okay? Yeah.
Are we going to go over franchise as well?
No.
Okay, I just had a quick question about franchise.
Can you hold it till the break? Because we don't have time. Okay. We don't cover franchises at all, but I'll be happy to answer it on break. Okay? Because we just won't have enough time to get through this. So we have this though, right? Right?
Yes.
Yes? Okay. So the directors and the shareholders consider the corporation's law of the state before they start putting their corporation together. And if you're big time or you want to be big time, you're going to usually be Delaware. Okay? So, here's the difference. Domestic is a corporation that is incorporated in a particular state. It's domestic in that state. It's a foreign corporation when it is compared to all other states other than the one in which it's incorporated, and it's alien if it's incorporated in another country and does business in the U.S. or on another planet. Incorporation procedures. A corporation is a creature of state statute law, right? California is governed by Corporations Code, right? So the organizers of the corporation have to comply with the incorporation statute of whatever state it is they're incorporating in. And they can incorporate in that one state and then do business in all other states in which it qualifies. And it qualifies by filing the certificate of authority. Skip that and come back to it in a second. A promoter. What's a promoter? A promoter is a person who organizes and starts the corporation. They negotiate and enter into contracts in advance of its formation, and they find the initial investor. So here's what a promoter is. A promoter is a guy like, let's say me and Tamiko decide to get together and let's form a corporation to sell widgets. And we'll call ourselves the promoters. What the promoter does is they promote this upcoming contemplated corporation. So Tamika and I, in contemplation of a corporation to sell widgets, we go out and we lease an office space. We're going to lease a building to have this corporation that's not incorporated yet. So we lease office space. We contact vendors and we say, we're going to make a corporation and we're going to need office supplies. We're going to need a printer. We're going to need a fax machine. We're going to need phone service, right? We're going to need light service, right? Gas and all of that, right? A microwave to eat on, right?
Right.
Vendor. All these are contracts that you and I are going to put together with third parties. No corporation yet, contemplated, right?
Right.
So we've negotiated contracts in advance of the formation of the corporation. Promoters. All right? We need to finance the corporation. So we're going to go out and find some angel investors. What's your name? In the back? Vidal. So Vidal is a multi-millionaire. Tamiko and I go to Vidal and say, hey, this is Vidal. So we've known each other since college, right?
Yeah.
I know you got $1 million. Just got a great idea.
That's right.
Tamiko and I have the idea for this revolutionary. And we need an investor to invest in. Do you want them to put, say, down $100,000, get us off the ground, get our manufacturing base together, and all of that? What do you think? Sure. We got $100,000 from our angel investor, Vidal. And let's say, what's your name? Ellen. She's also a multimillionaire, a friend from college. You say the same thing. Ellen, would you invest? $200,000? Now, in exchange, they're going to want shares of stock, right? That's a whole different story right now.
Right.
Yes, you'll invest? So we've got angel investors to invest in our corporation, right? So far, we've got $200,000 we can count on. Right?
Right.
Promoters. Corporation's not even set up yet. All right? It's important to note that. So our angel investors say yes, and our vendors say yes, and we sign contracts with the vendors. Okay? Let's say we got a 3-year lease, and 3 years that we are contemplating having to do this. Okay? Agreement. Here's what happens. The promoters often enter into contracts on behalf of the corporation prior to its actual incorporation. If the corporation never comes into existence, the promoters have personal liability for these debts. Unless the third party exempts them from the liability. Why would a third party do that? Would they?
If you do it up front in a contract with them, right?
Give them a share. The benefits outweigh the risk. Okay, let's look at this. There's a case which I think is in your book, and mine, or my old one. This is why I use this book as well. It goes further than your book, but I don't think you have this case. But listen to this case about promoter's liability. It's Coopers and Lybrand versus Fox. On November 3rd, 1981, Gary Fox met with a representative of Coopers and Lybrand, which is a national accounting firm. Fox informed Coopers that he was acting on behalf of a corporation he was in the process of forming. That makes him what? A promoter, right? It was going to be called G. Fox and Partners, Inc. He requested a tax opinion and other accounting services for this contemplated corporation from Coopers and Lybrand. Coopers accepted the engagement with the knowledge that the corporation was not yet in existence. The corporation was incorporated on December 4th, 1981. Coopers completed its work by mid-December and billed the corporation and Mr. Fox for $10,000 for services rendered. When neither Fox nor the corporation paid the bill, Coopers sued Fox as a promoter to recover the debt. The trial court held in favor of Fox, and Coopers appealed. So the court looked at it and said, okay, you sued Fox, but this is a corporation. So we're going to rule in favor of Fox, the promoter. Coopers and Lybrand appealed that decision. Issue: is Fox liable on the Coopers and Lybrand contract as a promoter? Yes or no? Everyone say no?
I would say no. The corporation was formed.
Corporation was formed. Anyone say yes? Fox is liable? No one says yes?
I don't know. I see like the contract between them. But you mean he personally entered into the contract for consulting services? So just that.
He entered into a contract as a promoter for a business that was not yet in existence. After the business came into existence, the business didn't pay the debt, and neither did Fox. Is Fox liable on the debt?
No. Well, it depends on the corporation. If there's limited liability, then no, the corporation is liable.
Well, he's a promoter, you don't know what his job is within the corporation. He might not even work there.
Want the answer?
Yeah.
I'll read it. Here's the court. As a preliminary matter, we reject Fox's argument that he was acting only as an agent for the future corporation. That was Fox's argument. I shouldn't be liable. I'm just an agent of the corporation. Lower court accepted that. The appellate court said, we reject that. And here's why. One cannot act as the agent of a non-existent principal, which was the corporation. It wasn't yet in place when Fox made the decision to do the contract with the Coopers and Lybrand, right? One cannot act as an agent for a non-existent principal. On the contrary, the uncontroverted facts place Fox squarely within the definition of a promoter. Coopers asserts that the trial court erred in finding that Fox was under no obligation to pay Cooper's fee in the absence of an agreement that he should be personally liable. We agree. As a general rule, promoters are personally liable for the contracts they make, though made on behalf of a corporation to be formed. The well-recognized exception to the general rule of promoter liability is that if the contracting party knows the corporation is not in existence but nevertheless agrees to look solely to that corporation and not to the promoter for payment, then the promoter incurs no personal liability. Release of the promoter depends on the intent of the parties. As the proponent of an alleged agreement to release the promoter from liability, the promoter has the burden of proving the release agreement. Fox didn't produce a document that released him from the agreement. Therefore, he failed to sustain his burden of proof, and the trial court erred in granting judgment in his favor. The Court of Appeals held that Fox was liable as a matter of law under the doctrine of promoter liability and reversed the decision. So, court said, nope, you're liable. And here's why. If you looked at what we said before, if the corporation never comes into existence, the promoters have joint personal liability on the contract, okay, follow me so far, unless the third party specifically exempts them from such liability. Cooper's didn't exempt them, right? Even if the corporation comes into existence, the corporation has to agree to accept the promoter's liability, number one. And the third party has to agree to accept that. So if I as a promoter go out and do all these different things, and the corporation never comes into existence, I'm automatically personally liable. If the corporation does come into existence, the corporation has to agree to accept these obligations that I have personal liability for, number one. And then the third party has to agree to allow the corporation to relieve me of liability. It's called a novation. It's a three-party agreement.
Wow.
Whereby the corporation agrees to relieve the promoter of liability, and the third party agrees to allow that to happen. Make sense?
Yes. So, in the example that you read, am I correct in asking that the court said that if the third party had only billed the corporation for the debt, that would be like an implied exemption of liability for the promoter? They said in there that if if Cooper's and Library as third party only sued the corporation, then the court would have said yes, the corporation is liable, okay? But if there's no money in the corporation, this promoter is still liable, and even if there is, he's still liable. Oh, I thought they said they billed the corporation.
No. The promoter is always liable for the contract that they do, personal. Unless, the only unless or caveat is if a novation is done, okay, that allows them to get out of the liability for that.
How do you convince someone to do a novation?
Well, I'm going to get to that. Yeah, that's part of what we're going to do when we set up when we incorporate. But that I wanted you to understand this before we get to incorporate, because this is before you actually do the incorporation. All right, the slides are kind of a little reversed. All right, but we got what a promoter is, right?
Yep.
The promoter goes out in advance of the thing being put together and promotes it, gets it all set, everything set up, so that when we actually get our articles of incorporation filed, we already have a place to do business, right? We have a place to meet. We have a place to make phone calls from and send out marketing materials, right? So we do that in advance. Now, we'll go back a little bit. Or we'll go forward and finish what happened. So if the corporation is formed, in this case it was, it becomes liable on a promoter's contract only if it agrees to become bound to the contract. And if the corporation agrees to be bound to the contract, the next step is the promoter still remains liable on the contract unless the parties enter into a novation. And the novation part means I, as a promoter, got the corporation to say, I'll take your debt, Mr. Promoter. Now I got to get the third parties who I contracted with to agree to allow the corporation to relieve me of liability. That's the novation. Three-party agreement. Got it? Mm-hmm. So now let's go back to the incorporators. The incorporators are simply the people or persons responsible for incorporating a corporation. So the incorporators' main job is to sign the articles of incorporation. Look on page, in your book, Look on page, 677. That's the incorporation example for your assignment. You see this down at the bottom? In witness thereof, being all the persons named above as the initial directors have executed the articles of incorporation. Everyone see that?
Mm-hmm.
That's the incorporators. They are the people that sign the articles of incorporation. That's an articles of incorporation on 677. The signatures at the bottom are the people who incorporated. All right? Now, how does the promoter get off of liability? Because if me and Tamiko are the promoters of the corporation, we probably want to have a stake in it too, right? So, when I prepare the articles of incorporation, I'm going to be one of the incorporators. And so is she. Right? And what's one of the first things we're going to do in our bylaws? What's one of the first things we're going to add in our bylaws? We're going to add in our bylaws, or even in the articles, we're going to say something to the effect of, all contracts that were signed and executed by the promoters are hereby the corporation's obligation.
That's right.
That's the first thing I'm going to do.
That's it.
Right?
That's right.
That's going to be in the articles of incorporation. Right?
Right.
And then, once we become incorporated, we're going to go and talk to all of those third parties, right? Or, we're going to have an agreement that's going to say, when third parties, when we're talking to them, that, we're going to do a corporation. So, we're not going to really be liable after the fact of the corporation. Will you sign this document saying that if the corporation agrees to accept the liability, that you will agree as a third party?
That's right.
And if you do that, we'll do business with you.
That's
if you
right.
don't, we'll find someone else
That's right.
who will.
We sure will.
So that corporation, that third party has a decision. Do I turn down business or do I accept business? Now, if I'm a smart promoter, I'm going to also say, hey, look, we already have angel investors. We got $400,000, $200,000 in the bank ready to start this thing. So you will get paid. Don't worry about it. Your debt is only $10,000. We got $200,000 in the bank. Just sign this thing and agree that once we incorporate, you'll look to the corporation if the corporation allows us to be free of the debt. Third party says yes. Corporation in the articles that we are the incorporators of, right? We're going to agree to that, right? So if the third party does it, then we as promoters are now off the hook because a novation has happened. Got that?
Yep.
So the novation comes first. When you're going out to your vendors, that's the novation.
You should.
Not necessarily.
You should.
The novation is the third party agreement, right? We can't have a novation until the corporation is.
So you go back to them and say,
we go back to them.
do a novation.
Yeah, we go back to them based on a contract that we do beforehand that says that they will.
So in the first contract is an
It's just me and them.
to novate.
It's just Tamika and I and the third party. But we're saying in our agreement that if the corporation agrees to allow us to be free of liability, you will agree to accept that.
So they're
But the contract is only between the two of us, right? Me and Tamika and the third party right now. It's not a novation. When the because the corporation is not set up yet, right? When the corporation is set up, then we go to the third party and say, remember that agreement you signed between you and I, where you would allow a novation if the corporation agreed to relieve us of liability? Well, guess what? They agreed. So now you're under an obligation to accept it. That's the smart way to do it.
Right.
The dumb way to do it would be to just, Tamika and I just go to the third party, create all these obligations, don't mention the fact that we're going to require a novation, and then after the fact go to them and say, we got the corporation to agree, will you agree? Third party says, no, we're not. We're going to keep you on the hook. Right? That would be a dumber way to do it, but even still, they still might say, yeah, we'll do it. Or they might say,
we'll do it in conjunction with both of them. We'll allow them to be on the hook, but you have to sign a personal guarantee in order for us to allow that. You know, there's all kinds of ways to work it. But the idea is, she and I were smart. We're going to talk to them and have them agree that if the corporation comes into this, because see, that's the caveat for them. Because their concern is, if the corporation is not in existence, then I got to depend on you only, and you might not be strong enough by yourself. But if I say, if the corporation does come into existence, you'll agree. They'll say, yeah. Make sense? Okay. It's now break time. Let's take let's go till 20 till. Take a break now until 20 till, so we really gotta finish this.